If you're a green card holder, or if someone in your family is, I need you to stop whatever you're doing and watch this video to the end. There is a change taking effect in 2026 that could quietly put your permanent resident status at risk, even if you've done everything right. I'm talking about the 2026 Biometric Exit Tracking Rule. And let me be absolutely clear from the very beginning, there is no new law coming in 2026. This isn't a rumor, it's not speculation, and it's not fear-mongering. What's actually happening is the digital implementation of a law passed nearly 3 decades ago, specifically the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, known as IIRIRA, is finally reaching completion. There may have been gaps in the system before, opportunities where things slipped through the cracks, but now, because of biometric technology, those gaps are closing permanently. And here's what makes this so dangerous for green card holders. The people most at risk are not the ones trying to break the rules. They're the ones who don't know that the technology has changed and that every single departure is now being tracked with precision. Today we're going to break down exactly what this rule is, who it affects, what triggers could put your residency in jeopardy, and most importantly, what you need to do right now. Stay with me. My name is Alexander Pierce. I'm a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. This channel is not about rumors, it's not about political opinions, it's about policies, real regulatory changes, actual USCIS actions, real court rulings, analyzed clearly and responsibly so you can make informed decisions. If you're new here, welcome. Hit subscribe and turn on notifications so you never miss an update. And before we go any further, I say this in every single video because it matters. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific situation. Now let's start with the foundation. What is the Biometric Exit Rule, and where does it actually come from? Congress first authorized biometric entry and exit tracking in the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, IIRIRA. That's nearly 3 decades ago. Since then, multiple pieces of legislation have reinforced this mandate, including the USA Patriot Act of 2001 and the Enhanced Border Security and Visa Entry Reform Act of 2002. In other words, the authority for this program is not new. What is new is that DHS has now moved into active implementation at major U.S. airports and land ports of entry. The technology has finally caught up with the mandate. In simple terms, when you leave the United States, the government now captures biometric data, primarily facial recognition, but also fingerprints at some ports, at the departure gate. That data is cross-referenced with your immigration records in CBP's automated targeting system. Here's the critical part for green card holders. Under INA Section 316 and related regulations, lawful permanent residents are required to maintain continuous residence in the United States. The biometric exit system creates a precise, time-stamped, government-verified record of every departure and return. But here's where this becomes truly critical, and this is what many green card holders are misunderstanding. Before this system, CBP relied primarily on self-reported travel history and airline manifests. That left significant room for ambiguity. With biometric exit tracking fully operational, there is now a federal database that can confirm exactly when you left, exactly when you returned, and how many days you spent outside the United States, calculated down to the hour. DHS initiated phased implementation beginning in late 2024 at major international airports including JFK, LAX, Miami, O'Hare, and Houston Bush Intercontinental. The 2026 expansion extends this to secondary airports and all U.S. land border crossings. Full operational capacity is projected by mid-2026. Let me be very specific here because this affects different people in different ways. Whether you received your green card through employment, EB-1, EB-2, EB-3, through family sponsorship, the diversity visa lottery, asylum, or any other pathway, the residency requirements apply to you equally. Under 8 CFR 211.1, a lawful permanent resident who remains outside the United States for more than 180 consecutive days without a reentry permit may be found to have abandoned their residency upon return. That threshold has not changed. What has changed is the enforcement mechanism. CBP officers can now pull up a verified biometric record of every trip you've taken over the past several years. This is what many green card holders are misunderstanding. It's not just about the 6-month rule. It's about the pattern. Even if no single trip exceeds 180 days, USCIS and CBP have long held, and immigration courts have upheld, that a pattern of extended absences can be evidence of abandonment. And here I want to emphasize something extremely important. The 180-day rule is not a guarantee. It's merely a warning sign. If you think staying out for 179 days means you're completely safe, you're misunderstanding the law. The law clearly states that even if you're outside for less than 6 months, if a CBP officer believes your primary intent is not to reside in the United States, they can challenge your green card. Proving your true intent is the real task. If you're spending 5 months outside the U.S. every year, that is now verifiable data in a federal database. If your work requires international travel, you need to be proactive. Document the business necessity of your trips. Maintain clear records of your U.S. ties, lease agreements, utility bills, bank accounts, tax returns. If you hold a 2-year conditional green card, typically through marriage, your travel history will be reviewed when you file Form I-751 to remove conditions. A pattern of extended absences can complicate that adjudication. U.S. citizens petitioning for family members via Form I-130 should know that once your relative receives their green card, residency rules apply immediately. Make sure they understand this before traveling internationally. H-1B holders should also be aware that biometric exit data will be used to verify your authorized period of stay. And here's something most people don't realize. These biometric records won't just affect your green card, they will directly impact your future citizenship application as well. When you file Form N-400 to apply for naturalization, USCIS will examine your continuous residence and physical presence requirements. These precise records from the biometric exit system will be used directly in that calculation. Even a one-day miscalculation could cause your citizenship application to be denied or significantly delayed. Let me make this real for you. Maria is a 44-year-old nurse who received her employment-based green card 3 years ago. Her mother back home became seriously ill. Maria traveled to care for her, 5 months on the first trip, then 4 months several months later during her mother's recovery. No single trip exceeded the 180-day threshold. Maria felt safe. But when she returned from her second trip, a CBP officer pulled up her biometric exit record. In the past 18 months, Maria had been outside the United States for a cumulative 9 months, more than half the time. The officer initiated secondary inspection and asked Maria to demonstrate her ties to the United States. She wasn't prepared. No lease agreement, no tax returns, no employment records. What should have been a routine re-entry became a 2-hour ordeal, and Maria was issued a notice indicating her residency would be subject to further review. Maria's story is not unusual, and under the new biometric exit system, it will become increasingly common. There's one detail most people are missing. Preparation before you travel is now just as important as the trip itself. Here is what I want you to do. Not eventually. Now. First, audit your travel history. Pull out your passport. Count your days. Add up your time outside the U.S. over the last 2 years. If any continuous stretch approaches 6 months, or if your overall pattern shows you've spent more time abroad than in the U.S., consult an immigration attorney before your next international trip. Second, assemble your residency documentation. Create a physical and digital folder containing your most recent U.S. federal tax returns, proof of U.S. employment or business, your U.S. lease or mortgage documents, U.S. bank statements, and any evidence of community ties, children in U.S. schools, medical records, memberships. Third, consider a re-entry permit. If your work or family situation requires extended international travel, Form I-131 allows you to apply for a re-entry permit before you leave. A valid permit protects your status for trips of up to 2 years. This is the most underutilized protection available to green card holders. Fourth, monitor USCIS and DHS updates. Subscribe to uscis.gov update emails and follow authoritative sources, including this channel, for regulatory developments. The biometric exit system is expanding. Knowing what's coming gives you time to prepare. Fifth, consult a licensed immigration attorney. If you have any doubt about your travel history, your documentation, or how this rule applies to your situation, do not guess. The cost of a consultation is nothing compared to the cost of losing your green card. This could affect you even if you believe your travel has been well within the limits, because the standard is not just duration, it's intent. Now let's zoom out. The biometric exit rule is part of a broader DHS initiative to close what enforcement officials have called the exit data gap. For decades, the U.S. government collected robust biometric entry data but had limited ability to verify exits. That asymmetry is now being systematically corrected. This is not a partisan issue. Every administration going back to the Clinton years has been directed by Congress to implement exit tracking. The technology has finally caught up with the mandate. As of this recording, there are no active federal court challenges specifically targeting the Biometric Exit Rule as it applies to green card holders. The statutory authority, rooted in IIRIRA and the Enhanced Border Security Act, has been consistently upheld. That said, organizations including the ACLU have raised due process concerns around facial recognition data retention. These are legitimate conversations to follow. The 2026 expansion to land border crossings is particularly significant for green card holders who commute across the U.S.-Canada or U.S.-Mexico border. Your cross-border travel will now generate a precise biometric record. DHS has indicated they will publish additional guidance on how biometric exit data will be used in residency abandonment determinations, expected by mid-2026. We will cover it here the moment it drops. However, the protection that comes from advanced preparation may not last forever. The window to organize your documentation is right now. I want to be direct with you about what's really at stake here. Your green card is not just a document. It is the legal foundation of your life in this country. It represents years of waiting, years of paperwork, years of sacrifice, yours and your family's. Your immigration status affects your ability to keep your job and build your career. It affects your ability to keep your family together. It affects your access to financial stability, your mortgage, your ability to plan for the future. And it affects your path to U.S. citizenship and everything that comes with it. I say this not to frighten you. I say it because the people who lose their green cards are almost never the people who set out to do something wrong. They are the people who didn't know what they didn't know. You're watching this video. That means you're paying attention. That already puts you ahead. But knowledge without action means nothing. Take the 5 steps seriously. Talk to an attorney. Get your documents in order. Understand your travel history. Your future in this country is worth protecting. If you want accurate, fast, and reliable immigration updates, subscribe to this channel right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. If this video helped you, or if you know someone who holds a green card and travels internationally, please share this video with them. It could make a real difference. Drop your visa category in the comments below. I read every single one. And if this content is valuable to you, hit the like button. It helps us reach more people who need this information. I'll see you in the next one. Stay informed, stay protected.